Tonight on The ReidOut, an absolutely stunning 24 hours of legal developments. 3 big cases, and at the center of them all, Donald Trump and his unlawful attempts to get in power and stay in power. First, in the state of New York, one of the star witnesses in Trump's criminal trial was back on the stand for a 3rd day of testimony. The prosecutors finished their questioning of former National Enquirer publisher David Pecker, where he acknowledged that the purpose of catching and killing Playboy model Karen McDougal's story about an affair with Trump was to help Trump during the 2016 election cycle. And Pecker said that he was aware that he was breaking campaign finance laws. Pecker also testified that he discussed McDougal with Trump while he was in the White House. This comes less than a day after 18 people were indicted in Arizona for their roles in an attempt to overturn Trump's loss in the 2020 election there, including 11 fake electors who submitted a document to Congress falsely declaring that Trump won the state, along with several Trump aides, including Rudy Giuliani, Mark Meadows, and Boris Epshteyn. Trump himself was not charged, but was referred to as an unindicted co-conspirator. And as all of this was happening in Washington, D.C. today, the Supreme Court heard oral arguments on Trump's claim that presidents have absolute immunity to essentially do whatever they want in office, crimes included, as long as it's, quote, an official act, which, according to Trump's lawyer, includes potentially staging a military coup or ordering the assassination of political opponents. Yes, that is a real argument that he tried to make.
Well, he's gone. Let's say this president who ordered the military to stage a coup. He's no longer president. He wasn't impeached. He couldn't be impeached. But he ordered the military to stage a coup, and you're saying that's an official act.
I think it would depend.
That's immune.
I think it would depend on the circumstances whether it was an official act. If it's an official act, there needs to be impeachment and conviction beforehand because the framers viewed that kind of
if
very
it's an
low
official
risk.
act, is it an official act?
If it's an official act, it's impeachment.
Is it an official act?
On the way you've described that hypothetical, it could well be. I just don't know. You'd have to, again, it's a fact-specific, context-specific determination.
That answer sounds to me as though it's like, yeah, under my test, it's an official act, but that sure sounds bad, doesn't it?
Well, it certainly sounds very bad.
Yeah, sounds really bad. As to most legal experts and humans here on Earth 1, this may seem like an absolutely absurd concept to even entertain in the country's highest court. But after nearly 3 hours of questioning, it appears that even as the court seems skeptical of the idea of absolute immunity, a handful, if not all, of the conservative justices are seemingly open to the argument that presidents are indeed entitled to at least some form of immunity from criminal prosecution, meaning they very well could remand the case back to D.C. Circuit Court for further proceedings, which would, you guessed it, delay Trump's federal election interference trial even further, all but guaranteeing that it will not be heard before the November election. But if you take a step back, these 3 stories essentially all have the same bottom line. Donald Trump allegedly used unlawful tactics to win the presidency in 2016 through hush money payments. And after he did win, he tried to remain in office unlawfully in 2020 after losing, allegedly conspiring to overturn the results of a Democratic election by way of fake electors, something that ultimately culminated in an insurrection at the U.S. Capitol. And even as we are just months away from another election, where the same guy is once again a nominee for the same office, the Supreme Court is wasting time having an intellectual debate about whether or not any of that is actually illegal. Make it make sense, because the stakes could not be higher, something Justice Ketanji Brown Jackson aptly pointed out during today's arguments.
What I'm, I guess, more worried about, you seem to be worried about the president being chilled. I think that we would have a really significant opposite problem if the president wasn't chilled. If someone with those kinds of powers, the most powerful person in the world, with the greatest amount of authority, could go into office knowing that there would be no potential penalty for committing crimes. I'm trying to understand what the disincentive is from turning the Oval Office into, the seat of criminal activity in this country.
Joining me now is Congressman Jamie Raskin of Maryland, a former member of the January 6th Select Committee. Congressman, thank you for being here. And I hope you will join me in this new reality, because can we now just stop pretending that when the Supreme Court meets to hold oral arguments and to make decisions, that they are even thinking about the Constitution. This Supreme Court majority, Leonard Leo 6, are so clearly politicians. The only difference between them and politicians like yourself is that you're honest about it. You are a Democratic politician. They are Republican politicians trying to achieve Republican goals. They didn't even pretend today that they had some constitutional argument. Even as a layperson, I didn't even hear them try. What I heard was them saying, we're going to make sure that Donald Trump is protected from prosecution, the end, and what are you going to do about it? Your thoughts?
Well, they're politicians who are not even subject to popular election, unlike me. They should move the Supreme Court over to the RNC headquarters because they're acting like a bunch of partisan operatives. The most astonishing thing for me today was Justice Alito's question. He actually asked whether holding a president criminally accountable for actual crimes committed, whether murder or coup or you name it, whether holding them accountable would actually encourage them to stage more violent coups to stay in office to avoid prosecution, which buys completely into Donald Trump's narcissistic criminal worldview. I mean, for all of American history, we've said presidents are subject to criminal prosecution if they commit crimes. That's why Gerald Ford pardoned Richard Nixon. That's why Bill Clinton agreed to give up his law license with the bar for 5 years so he wouldn't face criminal prosecution. Now they say, well, if you're really mean to Donald Trump and you hold him accountable the way every other American citizen is accountable, then he'll really overthrow the government. He'll really bring out the big guns, and we can't afford that. And that's a kind of masochistic capitulationism to Donald Trump's authoritarianism. I mean, of course, we've got to hold the president accountable to the law. I mean, it's the basic premise of our law that nobody is above the law, including the president. And when they say, oh, well, you can impeach and convict him and then you could prosecute him, again, that twists the language and turns it upside down in the Constitution. It says, even if you're impeached and convicted, nevertheless, you can still be prosecuted and tried and convicted and punished, presupposing that, of course, the president is subject to criminal law. And now we've got a bunch of justices who are asking questions that indicate that they are as corrupted as members of Congress who I serve with. When we get through this period, this miserable period of American history, and we will get through it, and we're going to beat them all in November, which is the only solution to this nonsense. These people are going to be fit only for selling incense and flowers at Dulles Airport.
Well, what is the solution? Because, it's a big if we get through this. They're trying to seemingly engineer a Republican victory so that the two oldest conservatives there, Clarence Thomas and Samuel Alito, can retire and be replaced by 30-year-old versions of themselves. That seems obvious, right? The bribe is sort of implied. But what legislatively can be done? I mean, Brett Kavanaugh has already gotten away, perhaps, with criminal activity. So he already feels a certain impunity. He got on the court, having been credibly accused of a sexual assault. That didn't matter. He wasn't even investigated. Clarence Thomas was credibly accused of also being a sex pest. He got away with that. I mean, they themselves, live with impunity. Is there anything that might be done, could be done, if Democrats were to take back the House and have enough Senate votes? Should any of them be impeached? Because it's clear corruption. It's so obvious.
Well, the American people have to insist upon the rule of law here. The president's primary job as a Republican judge on the D.C. Circuit put it, is to take care that the laws are faithfully executed, not completely betrayed and defeated. And she said it would be strikingly paradoxical if the person who's supposed to be taking care that the laws are faithfully executed, including all the election laws and the 12th Amendment and the 20th Amendment, which says you serve four years in office and you leave by noon on January 20th. If the person who's supposed to be enforcing the law is overturning the law, then we really don't have a constitutional democracy anymore. So the people have got to insist upon that. And what's happening, Joy, as I see it, is that as Donald Trump and his various January 6th aiders and abettors are being exposed now for what they did, finally, on January 6, 2021. And the factual case is just crashing in on them all over the country. Now they're shifting to the law to say, oh, well, of course, the president is not really held accountable under the law. And they're buying into Trump's argument that there's this absolute presidential immunity. Where did that come from? The Stork brought it. That is not in the Constitution. That's the very opposite of our Constitution, and it's the opposite of the impeachment judgment clause.
Well, then what's the answer legislatively? You're in Congress. Is it expanding the court? Is it putting 15 members on the court, as our friend Elie Mystal and others have said, expand the court? Like, what can be done to rein them in? Because at this point, they're stripping the 20th century reforms of the Warren Court and others down to the sparks. Like, we're almost going to have nothing left of the revolutionary American century. But before they're done, we'll be back to the mid-1800s legislatively and have a king.
Yeah. Well, I mean, here's the problem. We could build big political majorities in the country, and we must do that to restore the Voting Rights Act, which they eviscerated in Shelby County versus Holder. We can pass national legislation to restore Roe versus Wade and protect women's right to choose, and we must do that. But all of it could be appealed back to this right-wing reactionary Supreme Court. So we will have to take up the questions you're raising, but we've got to go one step at a time. You're several chess moves ahead of me, Joy. We've got to win this election, and we've got to go out and organize the whole country to understand that democracy's on the line and freedom is on the ballot, and our major weapon for constitutional self-defense at this moment is this election and getting everybody out to vote and to participate and then to defend the election results.